and welcome to today's webinar, The State of ADA App and Web Accessibility Lawsuits in 2023. My name is Bethany Servin, and I'm the Marketing Director here at UsableNet. We're delighted to have all of you with us, as well as our special guest speaker today, Jennifer Rusie, Principal at Jackson Lewis. This webinar is produced by UsableNet and covers our 2022 report on digital accessibility lawsuits. The report was released at the end of December 2022. Jason will tell you more about that in a bit. And that leads me to introducing our first speaker and the host for today's program, our Chief Innovation Officer and Advisor to the UsableNet CEO, Jason Taylor. Jason, can you go ahead and get us started with the agenda, please?
Thanks, Bethany, and thanks everybody for spending some time either live with us or on demand. I believe over 400 people signed up for this today, so I'm hoping Jennifer and I can give you some insights using some of the data that we've collected and produced a report from. And really what I'm going to get Jennifer to give us legal sort of color behind those numbers. So we're going to go over some of the findings that we've had in 2022. This is a report that we produce biannually, so twice a year, and we've been doing it for 5 years. So I also make some comments while we're presenting on sort of what we've seen over the last 5 years. I've also written a blog recently that you can find on our website on sort of like the 5-year trend or sort of view back over that time. We're going to try to look at the legal landscape, get Jennifer sort of on the ground. She works with hundreds of companies that have received lawsuits or demand letters. She's going to talk very practically about what she's seeing in this particular space, but also what you can do if you receive a demand letter or a lawsuit, and her best sort of practices in the first steps of that. And we're going to sort of hopefully give you sort of a tactical, for those people who are on the call that are looking for like, what can we do to reduce the risk or to increase accessibility and quickly sort of get in front of these types of lawsuits. We're going to talk to you quickly about practical things you can do to hopefully reduce your legal risk, but also increase the accessibility of your website. I actually just want Jennifer to maybe introduce herself and also just give us a little bit of a background. Jennifer, could you introduce yourself and just give us a background, please?
I would love to. Thank you so much, Jason. My name is Jennifer Rusie, and I am a partner in Jackson Lewis's Nashville, Tennessee office. I practice employment litigation defense, and I also, a huge part of my practice is accessibility of all kinds, website accessibility, which we're obviously discussing today, and also physical barriers and hotel regulations. I've been doing this for many years, and I expect it to continue for many more. I've spoken with Jason a few times on this, and it is always a pleasure.
Great, thanks, Jennifer. So let's get into just cover the methodology, because I think it's important to understand what's included in our report and maybe what's not included in our report, and how we go about tracking the data inside of our report. So the methodology behind the report is that we essentially track every federal and state funded filed ADA related lawsuit. That means that we actually read every ADA federally filed lawsuit, even if it's physical, because what we actually try to do is separate lawsuits which are filed against physical property over ones that are filed against web or app properties. So we filter those out, and then we look at the detail and we track information around those digital lawsuits. So when we talk about digital accessibility lawsuits, we are actually looking at all of them and then filtering out. So we only report on the digital side. We are looking at federally filed, and then also any that which are ADA claims under state law. So typically what we're seeing, the two biggest areas are California and New York, where people can make state claims, but claim that the ADA has been violated as part of that claim. So let's look at a typical week. I like to use a typical week because I think it brings home the idea of like what's really happening on a sort of weekly basis in this particular space. So every week there's over 80 lawsuits across the country claimed. About 20 of those are state filed and 80 of those are federally filed. I think one of the most important aspects of this information is that there's about 10 or 12 plaintiffs making up those 80 claims. So this isn't 80 lawsuits from 80 individuals, and we're going to see the numbers that this year about 4,000. It's not 4,000 individuals that have struggled with a website and then gone out and hired a lawyer to then actually take that website to task. You're going to start hearing from Jennifer about how this is sort of a collective activity, which is done primarily by a select number of plaintiffs and plaintiff firms. On a weekly basis, California, New York, and Florida hit the main three areas that states that you're going to find claims in, and we find on a weekly basis clusters around types of industries. That might be one week there might be a big focus on online shoe stores, and next week there might be a big focus on online winery websites. So essentially you can see sort of some type of trends around targeting essential different industries. If you could just go to the next one, Bethany. So I think it's also important to understand that most of these claims are very similar, even though they might come from 15 to 20 different plaintiff firms and maybe 15 to different types of plaintiffs. They follow a similar type of, someone might describe a template in terms of the information and the way that these claims are brought. So technically, they are typically a plaintiff that uses a screen reader that potentially could be blind or low vision, who is essentially the plaintiff that's making the case. They will typically be include in that some type of claim that the plaintiff couldn't achieve something on the website or the app. We'll get into with Jennifer about what sort of detail is provided. They will list a range of sort of technical violations based around a set of guidelines called the WCAG, which is the Web Content Accessibility Guidelines, which are sort of accepted standards around how you should build a website. But they'll include a list of things that have been found that don't follow those particular guidelines. They could include, and about 20% of them include some type of reference to any other technology on the site that also adds an additional barrier. So one of the things we'll talk about is things like widgets, which are being added to websites in the hope to make them more accessible, but particularly for screen reader users, they have problems with those widgets and they list them in the website. And many of the cases reference the lack of any accessibility policies or accessibility statements that are made on the website. So they're the sort of typical week and the typical claim, just to give you a sort of a feel for what these claims are.
I'm going to jump in for just a second and add a little color to that, Jason. As Jason noted, a lot of the claims, the complaints that we see in these matters are very, very similar. Like you said, it's like a template. The Second Circuit recently described the complaints in the accessibility area as a Mad Libs style complaint. They're pretty much the same, with fill in the blank with the name of the website, and then maybe what type of industry it is. Plaintiff likes going to restaurants, and then they fill in the blank the next time, likes shoes. And, it talks about, users unable to complete a task. Typically, they are frustratingly vague claims, and it is very frustrating for recipients of these lawsuits to determine what it is even that is wrong with their website. I see clients all the time, and they get a website, and they are naturally concerned and want to remediate the issue, but the complaint is typically not very conducive to directing them to any specific web page or issue that they can actually go in and fix.
Yeah, and actually, and I wanted to cover the big numbers. So if we open up the big number slide, so how does that all add up? How do those weekly sort of activities add up into the bigger numbers? And I think, this slide indicates the sort of last 5 years where it's grown from around 2,300 cases all the way up to over 4,000 cases now each year. I think the important thing to understand there again is this isn't 4,000 individuals that are frustrated with a website and then gone out and hired 4,000 lawyers. This is a very targeted group of plaintiffs and plaintiff firms. As I showed you in those sort of weekly numbers, this is a sort of concentration of about 15 plaintiff firms and about 25 plaintiffs that make up all of these claims. And to sort of give you an idea of how we've exploded, in 2017, where sort of the numbers really started to get bigger, there was sort of that was called a tough year, and that was only 814 lawsuits. So to give you an idea, like of the sort of explosion since 2017 is that sort of increase from around like 20 lawsuits a month up into about 100 lawsuits a week. So that gives you an idea of the scale. And I wanted to ask Jennifer, why do you think that is? Why do you not think that these lawsuits are starting to reduce? Why is there more and more lawsuits as opposed to less and less if it's been around so long?
It's a great question. As I think, especially we saw during the pandemic, the internet has become that much more important and that much more prolific. So there are just many e-commerce sites out there, and more people are using the internet than shopping at home. So there's that many more opportunities for plaintiffs who might be disabled who are trying to shop online. So we've got that part, and it's been successful. So if it's been successful in the past, why stop? And then lastly, as we're going to talk about here in a little bit, there has been some proposed legislation, and from time to time we see other proposed legislation that might implement standards that will help determine whether or not something is or is not a violation. So it'll be more clear cut for companies to determine whether or not their website is compliant, which I think will be much more difficult for plaintiffs to state a claim. And so I think that looming out there could be an issue for plaintiffs' attorneys trying to, get all they can before the cash cow stops.
So it's interesting. I mean, this slide that we're looking at right now, and I'll describe it, is basically where are these lawsuits filed? And I think it's important to cover this from a legal perspective, because I think this is probably the most important legal perspective, is why, and this slide basically shows that essentially New York and California dominate where filings are done. Florida's also has an up and down over the last year, but has always been sort of number 3. And between them, they represent a good 80 or 90% of all lawsuits. So, Jennifer, maybe you might want to take each of them separately. But for example, why is California, why is New York, and why is Florida? Why are the lawsuits being filed there from a legal perspective as opposed to other places?
Well, so I practice, I've handled cases in all of these states. I'm licensed in New York, and that's where I've seen the most of them, obviously, as you can see on the graph. And I think it started because there were most of the attorneys and plaintiffs who were in this space were there, and they started there, and they were very prolific. And so a lot of the body of law developed there. The judges are familiar with these cases. The plaintiffs' attorneys know that if they file a case there, They pretty much know what's going to happen with it. So it's a very comfortable, familiar place for them. In New York, you also have, in addition to the ADA, there are state and local New York City laws that plaintiffs can sue under, as the ADA only provides for injunctive relief, so we're remediating the website and attorney's fees. But the New York statutes, the state statutes provide for a small amount of damages. So there's, an additional incentive there. California is California. We all know that is the hotbed of all litigation. I saw on the list of attendees, I saw a couple of my colleagues in the accessibility space that were signed up for here. For this webinar, they can perhaps comment in the comments about why they file so many suits. But California has the Unruh Act, which permits plaintiffs to file a state law claim, and they get $4,000 in damages per violation. And the courts there consider every visit or deterred visit to be a violation. So typically it's about $8,000 a pop minimum. And you can stay in state court, just sue under the California statute. So that makes California very popular. And again, you've got, some plaintiffs' firms who are very familiar with these cases, who are located there. And then Florida, I also saw some of my Florida plaintiffs' accessibility colleagues signed up for this. Florida does not have a state statute that I've seen much activity with. There's it's usually just the federal law, but again, those courts are very familiar with this practice, and the attorneys know what's going to happen. It's very predictable. And again, they've got, for lack of a better word, there's a stable of plaintiffs, and there's a group of plaintiffs attorneys who are very familiar with this area of law. The other area we see is I see a lot in the Western District of Pennsylvania. There's a few firms there that are pretty active in this space. And there was, for a long time, a very favorable judge in the Western District of Pennsylvania who would get all of the cases that involved website accessibility. And I think that practice might be coming to an end. I have not seen that many Western District of Pennsylvania cases lately, so perhaps that's a reason.
Well, I'd also add to this. I think it's important for people to understand that there's a technical reason why these lawsuits are successful, and one of that reason is that, and Jennifer, you can give me your opinion about, because you work with many clients, this is still something that most companies have not addressed. It is, there's opportunity there for plaintiffs to use a website and find and have problems with it. The fact that today, after so long, companies are still sort of quite surprised when they get a lawsuit or demand letter. And many of the times, we have a conversation with a company, and this is the first time they've really considered it. They haven't actually thought that they need to do this. And I want to get your feedback on that, Jennifer. Do you see that that's changed over the years? Or are you still finding that the majority of people who get lawsuits haven't done a lot? So it doesn't, as a defending lawyer, does that, that doesn't give you a lot to, use against a lawsuit?
So I've seen, I would say now, people are much more likely to understand that there is something about website accessibility that's out there. I mean, when I first started doing this years and years ago, I didn't know that a website couldn't be accessible, and I've learned obviously very much about it. But there's still companies, especially smaller companies, and we'll talk about that in a minute, who aren't aware of this risk. And perhaps, they don't have an IT team, and they had no idea about this. And so you've got those companies, but then you also have bigger companies, and even if they've implemented strategies, websites there's no official standard out there. And that's really important to note. Everyone kind of goes by the WCAG, the Web Content Accessibility Guidelines, version 2.0 or 2.1 in level AA, to say, oh, if you meet these standards, you're accessible. But there's no actual case law out there right now that says that. There's no regulation for regular places of public accommodation. So there's always the question of, are you ADA accessible? What does that mean? And so unlike a physical accessibility space where you can take a measuring tape and measure and make sure that your grab bars are the exact right height, you know, and you know that I'm complying with the ADA, you don't have that security. And you can still be potentially subject to a lawsuit. And also websites are dynamic and they're always changing. And so sometimes, you know, maybe the person was just trying to get on your website at a time when your IT department was, you know, undergoing some changes. So, you know, and that is another, you know, source of frustration for clients. But I think, you know, as we'll talk about it, the best defense in this space is to really assess the website and audit it and make sure that you're, you know, keeping it as compliant as possible.
Yeah, and that sort of brings in, like you mentioned, a whole idea about change, and you know, one of the data points that we track is the type of industries that are targeted, and the slide we're looking at right now indicates essentially e-commerce, which is 77% of the sort of claim of the defendants. You know, outside of e-commerce, the other big ones are like food service, you know, entertainment, banking, travel. And there's a couple of reasons I feel that there might be some sort of focus reasons for this. You know, there's, as you saw, the numbers are large, so there needs to be a volume of targets, and there's lots and lots of e-commerce companies to target over banks, for example. But I think there's also things that Jennifer talked about there. You know, e-commerce sites are typically complicated. They're typically maybe built by an external firm, and maybe that external firm didn't take accessibility seriously. They change a lot. You know, it's not like a physical space that Jennifer talked about. You know, once you build a restaurant and make sure it's accessible physically, it's not going to change until it gets remodeled, which is every 20 or 30 years. A website changes every month in the e-commerce space. So these are sort of some technical reasons why e-commerce, I believe, are sort of highly targeted by plaintiffs. They're also very easy to visit. Obviously, you need a plaintiff to visit the website and, you know, experience it and report problems into that claim. Jennifer, you talked about, you know, I know you work with a lot of e-commerce firms, but and that sort of combines the next slide. You know, where do you see the biggest sort of like focus in terms of clients that come to you, in terms of types and then also size of companies?
And like you saw, again, the majority are e-commerce. I've seen probably at least a couple on every one of those on the list. There's an attorney out there who targets higher education institutions. And so, you know, I've done a lot of cases for colleges and universities. But, you know, e-commerce is definitely the number one. And I think that's, like you said, there's just so many sites out there. And originally, you know, it was your really, really big e-commerce sites. And now, you know, I had one last year and it was a company of one. You know, it was just one person who had his own, basically, he's like a solo practitioner, and he didn't know anything about accessibility. And of course, it was very troubling to him to, you know, get the demand, get the complaint. And that's another important note that a lot of times people ask me is there a threshold number of employees for the ADA to apply? Because in the employment context, there is, but there's not in Title III of the ADA. There's not a threshold limit of how much money or revenue that the company makes. There's not an employee limit. It's basically any publicly facing website that is considered a quote unquote place of public accommodation could be susceptible to ADA claims. And so that's why it's important for all companies, if they're putting themselves out there on the internet, to really be cognizant of their ADA obligations.
Yeah, and this slide that says basically no company is too small, and really the data points to, and we track sort of like a company size under 10 million and above 10 million, and essentially see that there's a slight increase, but the majority now are coming from companies under 10 million in revenue. That might mean that, you know, they're running out of some of the bigger players, but, you know, for example, you know, I think 85 or 90% of the retail 500 have received lawsuits over the last 5 years, many of them multiple times. So essentially, there isn't a sort of, and I think Jennifer will probably point to the fact that some plaintiffs like to work with to bigger companies, target bigger companies, and some like to target smaller companies. I do really, when Jennifer works with smaller companies, especially companies maybe they've spent a very small amount of money on their website, they bought it off a CMS company. They may have added some plugins to that, like BizRate or some like marketing plugins. Jennifer, can you talk about, like, is a company responsible for the website, or is the company that made it responsible for the accessibility? And what about third-party, plugins like marketing, email collection, and BizRate plugins? Who's responsible for the accessibility of that? It's sort of in a legal term.
The owner and operator of the website that is considered to be the place of public accommodation is who is responsible. There is an opportunity perhaps for that entity, the company, to go after whoever designed the website for them, or the third party, if that is the issue. Maybe there's an indemnification agreement in their contract, which I suggest that all companies try to do if they are getting someone else to do anything with their website. But the way the law is written, it is the owner or operator of the website who is the entity that bears the responsibility.
Yeah, and I think that point is something that is a surprise even to the big companies, right? Lots of websites are built by lots of different things. There might be a core website built by a team, but then additional functionalities added from other companies that provide that functionality. But the buck stops with who owns the website, and I think that's a big surprise to companies. And there's not much you can do unless you proactively thought about this beforehand. So we obviously recommend to clients to make sure that anything that they're buying in the future, any updates that they're doing, any renewals that they're doing in contracts with regard to people who build their website or adding third-party features to their website, they've got to make sure that there's a requirement in there for making sure that it's accessible. That still doesn't mean that they might, if the company doesn't make it accessible, you put it up there and you do business from it, you can still get a lawsuit, and you'd have to sue the company for not doing their responsibility in the contract. You can't pass on that responsibility, even if your contract says that company should have made it accessible. But it's a big surprise, I think, to people to realize that all of these third-party things that they can add to a website, if they add it to their website, they're responsible legally for the accessibility of that. And I think that's a big thing that needs to be rectified in the industry in terms of making sure things are accessible when you're selling it to companies, adding it to their website. So let's get into, I think there's like one more slide on the actual numbers, and then we're going to get Jennifer to talk about, how to do stuff. And I think, the legal landscape we've talked about a little bit, but again, I think it's worth understanding that this is a sort of focused industry. It's a very aggressive sort of, you can call it aggressive advocacy around plaintiffs that essentially are working to make sure that the digital space is becoming accessible. Other people might describe it as opportunistic plaintiff firms that are finding a way to get lots of fees. So there's, the truth is somewhere in the middle. But essentially, what you really need to understand is this is really dominated by, for example, the top 10 plaintiff firms represent 75% of the filings, where in contrast, the top 10 defense firms only represent 19% of the defense, right? So there's only, for example, 67 plaintiffs last year that filed lawsuits in federal court. This also is useful to understand because, for example, I can now say to Jennifer, she's a defense attorney, do you know the plaintiff firm that has sued me? And do you know the plaintiff that has sued me? What do you recommend to do? So Jennifer, maybe you could talk about that. Like, how do you give advice to companies based on the plaintiff or the plaintiff firm that has made the claim?
That's actually a really good question, because this is very much a repeat player scenario. And it's, you know, a lot of us deal with the same people over and over again. And, you know, so you have a lot of predictability as to, you know, basically what they're after and what's going to happen. And, you know, do they want to settle? Do they want to fight? You know, and if they do want to settle, what's going to be your typical range? And so I think it is a great, tool for us as defense attorneys, because we know what to expect. And again, because we do deal with people so much, I typically have a very good relationship with the attorneys on the other side of the case. And we're usually, you know, as we'll talk about, most of these cases settle, and we're usually able to settle it pretty quickly and, you know, favorably. And, you know, if there is an issue, we're typically able to work it out. So it typically gives the clients a degree of comfort knowing that it's not a big unknown out there. We have a really good roadmap for how the litigation is going to go.
Yeah, and it's going to lead us nicely into the next slide, which really is about what you should do. Actually, so one more slide on the data. I apologize, and I just wanted to get Jennifer's read on accessibility widgets. Now, for those people who don't know what a widget is, you may have seen them on sites. Essentially, they're an icon. When you click on them, they bring up a panel. That panel sort of suggests some really, it looks to suggest some nice additional features, but exist to maybe help you use the website, like increase the font size, change the contrast color, maybe even read you the content on the website. These widgets have become very popular because they're reasonably cheap. They talk about offering a lot of protection with regard to from lawsuits and making sure your website is accessible. From a data perspective, what we do is when a company gets sued, we instantly go to their website and look to see if they use a widget. If they use a widget, we track to the fact that widget didn't help them avoid that lawsuit. And in the case right now, it's about 20% of lawsuits. The website already has a widget on it. So essentially, I don't think it necessarily stops plaintiff firms targeting that particular website. And I wanted Jennifer's opinion from a legal perspective, what she felt like, you know, does it help you if you're a company to avoid lawsuits if you add one of these like accessibility widgets on your site?
It's really interesting because the first time I heard about these, I remember thinking, wow, that's amazing. And, you know, it's like, that sounds really good. And it's so cheap, like, you know, but, you know, I think when you think if something's too good to be true, it probably is. And as I've seen the popularity of these increase on, you know, so many websites that I visit, just in my day-to-day life, I see, you know, a little widget on there. So I can see that they're very, very popular, but in my experience, it has, and as you see, the data shows it's not preventing companies from getting sued, which I think is at least going to be a huge incentive for why you're installing them. So I don't think it's always accomplishing that goal. And the other goal would be to make your website accessible. And I've read at least one opinion in a federal court stating that they do not believe that the addition of a widget to or an overlay, you know, these different things to a website renders it ADA accessible. And I think the reasoning might be, but I mean, again, we don't have any standards, but also, as you see on that second bullet point, that a lot of times the allegation is that the widgets actually interfere with the screen reader and they actually make it even more difficult for the screen readers to function. And so I think that perhaps it's, you know, if you were operating it without a screen reader, perhaps it helps you, but if you are using a screen reader, it becomes really, really difficult. So I think you would want to, you know, think long and hard before you did that. I like to think of it as a Band-Aid as opposed to actually curing the problem. Because if you go in and you recode the website to make it meet those standards for the WCAG 2.1, then you're curing the infection. As opposed to, you know, just putting a Band-Aid on the bruise here.
Great. And let's move into like sort of Jennifer's sort of opinions around the current federal response. And so essentially Jennifer talked about there's been efforts over the years to be like, you know, more like the actual clear up the ADA. What does it mean to be accessible? What are the standards? Who does it apply to? What size company does it apply to? There's been different efforts. There's a current effort which sort of stands out because it's got a lot of support from the disability community where the other efforts didn't have. It's called the Website Software Application Accessibility Act. It's been brought in conjunction with, I think, a bipartisan Senate or House committee. My view is that you know, it has more chance than the past, but it's still a long way off. I don't know what, Jennifer, you felt about this.
I think you're right. This is one of the few areas where businesses actually really want some regulation, because right now it's kind of the Wild West and no one knows whether or not their website is accessible. But if there were, you know, these actual standards out there, then a business could look and they could basically go through a checklist and be like, boom, 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 my website is accessible. And so I think that's why you do have a lot of bipartisan support for this bill. And the way this one works is it basically is going to have, you know, some standards, and it still would permit plaintiffs to bring a, you know, private cause of action without exhausting any administrative remedies, which is the case now. And that is something under that the disability advocacy community has always wanted. And so it's not giving up that piece. But on the other hand, it should give a little bit of clarity for the businesses as to what accessibility means. As Jason mentioned, this is a long way off. This is in its infancy. It's only just been introduced. I think it would take a really long time to get enacted. And the way it even says, it reads is that within 2 years, some standards need to be, you know, proposed and implemented. So I think we are several years away from this statute becoming law, if it does become law. So I think we will certainly see, continue to see website accessibility cases for the next several years.
Great. So next one, Jennifer, what should we do if you get a demand letter on a lawsuit? What's your standard sort of best practice?
I know you'll be shocked to know that my first thing is to get a lawyer. But I do think that's really important. Particularly if you get a demand letter, there's a bunch of attorneys out there who send demand letters en masse, have no intention of ever following up. And I have safely ignored demand letters from certain attorneys and have never heard back from them. So if you reach out and get an attorney when you've got a demand letter, hopefully that attorney can tell you if it's kind of safe to ignore it. And then, you know, I would certainly look at the website and go through it there, but, you know, maybe you're safe to not respond to it. Or maybe it's an attorney who will certainly follow up and maybe will increase their settlement demand if they've had to actually file a lawsuit and you've ignored that demand letter. So an attorney should be able to give you that advice. Also, you know, if you've gotten a lawsuit, you need to get an attorney because companies cannot represent themselves in court. And again, you know, like I said, this is a close-knit kind of repeat player community. Hopefully the attorney that you has some experience in this and they can guide you through the litigation and let you know a roadmap of what's going to happen and then help you, you know, whether you're going to settle it or, you know, litigate. So step 2, after you get the attorney is, and this is if you get a demand letter or a lawsuit, you're going to want to assess the lawsuit. Audit it in some fashion. Some people have internal IT teams that can do it and get the, you know, WCAG 2.1 standards and run a test on it. There are free scans out there. I don't recommend them because they are not good. That's the reason they are free. There's a lot of false positives and false negatives on them. And in fact, that's what I know that some plaintiffs' attorneys out there run the websites through. This one site called Power Mapper that I know has given some false positives and negatives in the past. And, so there's some free tools, but I don't recommend them. I would get some sort of a reputable company to conduct an audit of the website. And then, you can look at it and see, do we have a violation? Do we not? And like we've said before, typically there is a violation. It's almost impossible to have a perfect website. But, maybe it's really de minimis issues. And that's something that you could base a defense on. And then certainly the last bullet there is you want to remediate any barriers to access. If you do have any issues, I think you're going to want to, go in and fix them, because typically if you settle, that is going to be a term of the settlement agreement. And like we said, that's how 95% of these cases settle. There've only been a couple of trials in the whole country on this issue. So like I said, typically that's going to be a term of a settlement agreement. And you also want to comply with the law, and you want to prevent future lawsuits. So the remediation piece is very, very important. And if you have engaged, a third party to audit the website, they can give you hopefully some tools as to how to do that.
Yeah, my input or my sort of observations and where it works best is sort of to instantly separate the two things, which is there's what are you going to do legally, and then what are you going to do technically, and not wait for the technical thing to start after you've decided what you're going to do legally. Because essentially, by getting a demand letter and getting a lawsuit, essentially you're under notice that someone's looking at you. And I think, Jennifer, it's important for people to understand that even if you probably had this experience where even if you settle, and typically those settling agreements might be, you've got to make the website accessible, but you've got 2 years.
Right.
But that isn't a settlement with the world. That's a settlement with one plaintiff. So easily a second plaintiff can come along and sue you while you're doing that work. And
I can tell you that is maybe the biggest source of frustration from my clients, is that, you can, you pay this money, and as a question I always get is, how much are the settlements? They're typically between $5,000 and $20,000. I would say the average are between 10 and 15. And in an agreement to, remediate the website, meet the WCAG 2.1, 2.0 standards. But again, some other plaintiff could come along who you have not made an agreement with, if you haven't fixed that website, and you could get hit with another lawsuit. And, I've had many clients who have had multiple lawsuits, or if you operate many websites, that's another thing is, you want to check it out. If you have a company that operates a number of websites, and one of your websites, you get a demand letter about, or a complaint, I would certainly assess all of them. And, go ahead and start doing it. You don't have to wait until you've reached that settlement agreement. I like to think of it like if you have a broken step and someone trips on it, you're not going to just preserve it there for the litigation. You want to fix that step so no one else trips on it.
Yeah, and that sort of leads me to like, what could you do technically right now to get started to reduce your risk and increase the accessibility of your website? And the bad news that you've probably picked up across this sort of data is that there's active plaintiffs out there looking for websites with problems, right? That's the bad news. The good news is they don't spend a lot of time doing that. They have a very specific way of going about that. So if you go ahead and do what they do right now, and you remediate based on what you find, what you think a plaintiff would find, you will be increasing the accessibility of your website and significantly reducing your risk at the sort of best value for sort of time and money. So the first thing you got to understand is that these lawsuits are essentially, they're aimed at public data. So I'd think first about, what are the most public digital experiences we have, most public websites, most public apps, what's our most public things like PDFs and other digital stuff. But essentially sort of a priority list of your digital properties. You could start with, for example, we have a service at UsableNet, where you can actually quickly take a look at, where does your website stand in terms of, is it in good shape or is it in bad shape? Again, that's going to help you prioritize probably which one of the websites you're going to focus on. As you saw in a typical claim, the claim is made by a plaintiff that uses a screen reader. So the first thing I would do is get someone who uses a screen reader for day-to-day use and have them try to complete the main tasks that you would expect anybody to complete on your website. That's going to give you a good source of data. That's either going to give you a source of data to worry about and get your team to instantly focus on. Plus, your team would instantly know that an individual who just happened to use a screen reader has a problem. So you know that you've got problems. That's going to motivate a team to fix it. Or it could be giving you a good amount of data to say, actually, we're in a good place, that the screen reader user could complete the tasks that we expect them to complete. Yeah, I would take, I would make sure that you're contacting whoever you paid to build your website, whether that's an internal team, an external vendor, and ask them, what have they done about accessibility? Put them under pressure to deliver you better accessibility. I would create some type of internal statement about what you're going to do. The reason to create a statement would be to get buy-in from the different departments that need to be involved, maybe funding that's going to be needed. So, starting a conversation about, well, what's our statement around accessibility, and what are we prepared to do? That will, generate the type of buy-in that you need from different departments. And essentially, if you go about doing what the plaintiff firm does, use the website with a screen reader, use an automatic tool to test all the top pages, put up an accessibility statement, you will significantly increase the accessibility of your site and reduce the risk against these plaintiff firms, because that's what they're doing to find you in the first place. So I think we're done on our slides. I see a bunch of questions. Bethany, hopefully you've done a little bit of sort of filtering and decide which ones we should start with first. Just for everybody to know, we might run out of time, but we will answer every question. Jennifer and I can actually pull the list. Bethany will then send the answers to you individually based on your email. So please feel free to put questions in, even if you feel like we're going to run out of time, because we will make sure they get answered.
Great. Thank you, Jason. Thank you, Jennifer. So I thought we'd start really generally here. Someone asked, what is a demand letter?
So a demand letter is, it's not a lawsuit, it's just a letter like it is. And it's usually really vague, actually, even vaguer than the lawsuits. And it says, we represent a person who has visual disabilities and they were unable to access your website. If you please contact us so that we can discuss this violation. And so, some of them are some of them are really long and some of them are literally like 2 sentences. But it's basically saying, notifying you that they have a client who has experienced some accessibility barriers. It may or may not set forth an actual demand in that letter, but that's what that is.
Yeah, and I think it's important to understand that demand letters, and Jennifer, you can give us your opinion on this, but right now we see probably there's twice as many demand letters as lawsuits out there. And I think Jennifer's right in saying that they are sort of a precursor to lawsuits in some cases. In many cases, they're not a precursor to a lawsuit. They're a sort of, hey, can we demand some type of settlement early on without going to court? And I think it goes back to Jennifer's point, which is, even if you have in-house counsel, to take advice from a well-established ADA defense counsel on what is this plaintiff firm like, what do they do, what is their history, it might mean that whether that demand letter is going to go to a lawsuit. There are some of these plaintiff firms absolutely will go to a lawsuit if you don't respond to that. Some you could probably not respond to because they never go to a lawsuit.
And
So
in fact,
again,
there
that-
was, oh,
yeah,
sorry.
Jennifer?
I was
No,
gonna say,
Jennifer,
in fact, I believe it was the Riverside County, California DA went after a couple of attorneys for sending out demand letters and having no intention whatsoever for suing. So it's definitely a situation. There was one question I wanted to touch on that I was scrolling through them that we had meant to touch on. So I just want to be sure that we say it. The question was, if the website, you know, if the plaintiff's in New York, like, what does it matter where the defendant is? That's the thing with the internet, it goes everywhere. And so you can be located, you know, absolutely anywhere. You could be international. I mean, you're gonna have a whole problem serving you to go through the Hague Treaty to do that. But if you are anywhere, and the plaintiff can access your website, then you can be held into court in wherever that is. I have had a few instances where I had a client I had one who didn't ship to California. They're like, we don't do sales in California. We've never shipped there. We don't have any business there. And I was able to get that one dismissed because there was no jurisdiction. The personal jurisdiction lacked. But you, even if you're not in New York, you know, you still could be at risk of getting sued in New York or Florida or California.
yeah, and I can confirm that we've helped companies, international companies who are not based in the United States, but sell to the United States and sell in New York City, and that means that they are subject to New York law because they provide services or sell product in New York.
Point. Can you talk about accessibility statements? They aren't required by law. They seem to be proliferating, and they seem to provide a list of claims that could form the basis of a suit.
I don't like those kind of accessibility statements. I am a fan of website accessibility statements, but I like them to be very simple because I think they're helpful for someone who is trying to navigate your website. You've got it on there. It says, hey, we're really committed to accessibility. I mean, obviously only put that if you are, and give a number or an email and say, if you're having difficulty accessing any of the information on this website, like, please contact us, you know, at this number, this email, and have someone who is actually answering those emails, answering those phones, you know, so that you can provide that person with the information and services that they need, you know, perhaps in a different manner. It's just a customer service tool, but it also does show that you are, you know, concerned about accessibility. Unfortunately, in this area law, it's a strict liability thing. So it doesn't matter how well-intentioned you are. But I think if it ever, you know, you ever did come to trial, you know, show that to the judge. It certainly doesn't hurt. But it is out there to, you know, to help the public. And you also have the argument that, hey, we've got this out there and they chose to sue us instead of, you know, actually just calling this number, which, you know, to a judge might be a persuasive argument. But, you know, some people put these website claims and are like, our website's not ready yet, but I wouldn't ever go say, hey, our website doesn't meet the standards. I would just say, hey, if you're having difficulty with anything, here's the number and call us.
I would generally agree, but basically the accessibility statement is, I think, it's a twofold. One, it's about showing that you actually are taking accessibility seriously, meaning that you know about it, and actually your customers, if they're having problems, contact us. I agree with Jennifer. It's a component that she can use in negotiations when someone sues. You say, why didn't they call the number? You know, it's clearly there. You can call the number, and I would agree with her that a statement should be broad in nature to say that, you know, this is something, you know, accessibility. We want to make sure that everyone can use our website. If you can't use our website, this is how you contact us. That one of the internal values of an accessibility statement, whatever you're going to write, is it gets the conversation going. But we need to make sure that we actually know what to do if someone with a screen reader calls us and says, hey, I can't use your website. What is actually going to happen from there on? You know, who's going to take that? Who's the project manager for it? What is going to be done? How's it going to be prioritized? How's it going to be escalated? These are important questions that come off the back of when people start talking about accessibility statements internally.
I want to note, I'm sorry, I'm just jumping around here, but I saw a question and I really wanted to say this one. It said, someone said,
Yeah.
do you have any advice for dealing specifically with Jay Brodsky? I have quite a few clients who get demand letters from him. And the reason I say that is because I mentioned him in the last webinar that we did, and he only sends demand letters and he files things with state agencies. So there's no public record of him. And the only public record was the transcript of the webinar. So it's going to put that out there again. He is an interesting character. He's in New York. Typically, he likes to go after hotel, restaurants, menus. And usually they're PDFs. And that is something that I've seen with a lot of other hotels, is that they put up a PDF on their website and that is not accessible. It's a really easy fix. And so that's something, if you have any PDFs on your website, I would check that and fix it real quick.
How long will it take to resolve any lawsuits related to your website?
Well, and I'm assuming that that means that you're settling it. It's because if you're litigating it, it could take a very long time. But if you are having a typical settlement situation, sometimes it depends. Sometimes there's a strategy in dragging it out. And so that's something that you can do. But you could also, again, I'm really familiar with some of these people. We say, hey, look, we know where this is going to settle. Like, can we just cut to the chase and get to that number? And it could be, boom, 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 and you could do it in a month. You have to draft the settlement agreement, do all this. The courts will typically give you lots of extensions of time because the courts are encouraging all these cases to settle. They don't want to hear them. They're clogging up their dockets. So as long as you're talking settlement, the court's going to extend your deadlines to file an answer, which is going to, again, make it cheaper for you if you're litigating it. But I would say the typical kind of timeline is maybe 1 to 3 months. But it's a lot of it is just sort of how busy is the attorney? How long does it take to get the settlement agreement drafted and reviewed and signed off? But it's really not something that typically drags on for a long, long time.
Okay, great. We are at the 1 o'clock mark. Thank you very much. And this webinar is now ended.